Good evening, everyone.
Good evening, Your Honor.
Good evening. Before we begin, I want to make sure we have counsel for both parties available here today. Do we have the counsel for the government
Yes, Your Honor.
and counsel for the defense?
Good evening, Your Honor.
And do we have both scoring judges?
Yes, yes,
Or all the scoring judges? I believe there's several.
Yes.
yep,
All
Yes.
right. I've been given the go-ahead to proceed, so we'll call the case in just a moment here. We're on the record now in the case of United States v. Elizabeth Bartlett. And if I could get both parties to enter appearances at this time.
Yes, Your Honor. Good afternoon. My name is Katie Jerome, and I will be representing the government today.
And for the defense.
Good evening, Your Honor. Nathan Mostow appearing on behalf of the defense.
All right. Do we have any motions we need to address now or housekeeping matters?
Yes, Your Honor. We have a few housekeeping matters as well as one motion.
All right, you can proceed with your housekeeping matters first, please.
May we assume that all objections are constructively heard outside the presence of the jury?
Of course.
May we assume that all witnesses have been constructively sworn in?
Yes.
Due to the nature of this proceeding, when we share our screen to show exhibits that have not been pre-admitted to opposing counsel and the witness, may we do so constructively outside the presence of the jury?
That's fine.
Pursuant to pretrial order number 9, exhibits 3, 11, and 14 have been pre-admitted. Do we have Your Honor's permission to publish those exhibits throughout the course of the trial should we need to?
I'm sorry, could you repeat those numbers for me again, Counselor, please?
Yes, Your Honor. It's exhibits 3, 11, and 14.
Is that your understanding, Counsel for Defense?
Yes, Your Honor.
All right. Anything further?
Yes,
As
Your
far as
Honor.
housekeeping?
Yes. After conversation with defense counsel during meet and confer, we've stipulated to the admissibility of the following exhibits to be used today. Exhibit 6, which is the Bartlett prenuptial agreement. Exhibit 8, which is a photograph of the gloves. And Exhibit 10, which is the shell casing. Do we have Your Honor's permission to move those exhibits into evidence at this time?
Any objection from Defense Counsel?
No objection.
All right, they'll be admitted and they'll be treated as pre-admitted.
After conversation with defense counsel, Your Honor, during one of my presentations, during the course of my direct examination, I will have Exhibit 6 as well as Exhibit 7 shown on the screen side by side. Exhibit 6 has been pre-admitted as we just established. Exhibit 7, may we establish that that be constructively not shown to the jury until it is admitted, although it is on the screen at the same time?
Have you shown it to opposing counsel as it's going to appear upon admission?
I have, Your Honor.
They have no objection?
Not to my knowledge.
So we just can't redact it is what the problem is. We can't visually redact it. So you want to constructively do so?
Yes.
No problem.
Thank you, Your Honor. And during meet and confer, we stipulated to our motion in limine, which is precluding any mention of the previous trial in 1998 and the result thereof. And should any testimony become necessary from that trial here today for purposes of impeachment or anything else, we agreed with opposing counsel that it be referred to as a prior proceeding.
All right. Now give the defense an opportunity. Do you have any preliminary matters that you'd like to address prior to addressing motions in limine?
No preliminary matters, Your Honor.
All right, then I'll head back for the counsel for the government. Do you have any motions in limine you'd like to proceed with?
No, Your Honor, that was the stipulation to our motion in limine that we agreed during meet and confer.
Oh, my mistake. All right, and then we have no motions for the defense as well?
That's correct.
All right, so are we ready to proceed with opening statements?
Yes, Your Honor.
Yes.
You may proceed.
Thank you. Her print, her presence, and her motive. It's December 31st of 1997. It's New Year's Eve. 28-year-old Elizabeth Bartlett, this defendant, She's not out partying with her friends. No, she's stuck at home. Her 67-year-old husband, Martin Bartlett, was asleep before 10 p.m., well before the start of the new year. In fact, Martin Bartlett never got to see New Year's Day, because in the early morning hours of January 1st of 1998, this defendant shot and killed him. Good evening, members of the jury. My name is Katie Jerome, and I represent the United States. Today, I will prove to you, beyond a reasonable doubt, that the defendant is guilty of murder in the first degree for the following 3 reasons. This defendant's print, this defendant's presence, and this defendant's motive. Now, before we understand what happened on January 1st of 1998, we need to take a step back to December of 1997. That month, Martin Bartlett suspected that the defendant was having an affair. So he confronted her, and he threatened to divorce her. And not even 1 month later, he was murdered in his own home by his own wife. Which brings me to my first point. This defendant's print. You'll learn that this case was investigated by Deputy Commissioner C.J. Concannon of the Philadelphia Police Department. In 1998, then Detective Concannon determined that Martin Bartlett had been shot with a .22 caliber bullet. She recovered a box of 50 .22 caliber bullets from the home, with just 1 bullet missing. She then recovered a shell casing consistent with the .22 caliber bullet that killed Martin Bartlett. Not only that, but it was consistent with Martin Bartlett's .22 caliber handgun, a gun that was never recovered. But what was recovered was that discharged .22 caliber shell casing, a shell casing that was too damaged for fingerprint testing back in 1998. But in 2022, using a new technique called electrostatic fingerprinting, a single print was revealed on that shell casing. A print that was a 20-point match to this defendant's right index fingertip. A print that pointed directly at this defendant and no one else. This brings me to my second point. This defendant's presence. On January 1st, at 2:30 a.m., then Detective Concannon was notified of a reported homicide at 1200 Dragon Drive in Ardmore, Pennsylvania. With a bullet-sized hole in his head, Martin Bartlett was pronounced dead at the scene. So, Detective Concannon preserved the scene for forensics and proceeded to interview the defendant. This defendant claimed that at some point after 2 a.m., a 6'3" burglar broke in and murdered her husband. That she was lying in bed right next to her husband when he was shot and killed. And that burglar was wearing gloves the entire time. You'll learn that despite the defendant's claims that her husband was killed after 2 a.m., Martin Bartlett's time of death was between midnight and 12:30 a.m. And by the end of this trial, the evidence will show you that this defendant used that 2-hour gap to her advantage. Despite her story that she was in bed with her husband when he was shot, not a trace of blood or gunshot residue was found on her. But what was covered in gunshot residue and her husband's blood was a pair of gloves. A pair of women's small gloves that this defendant admitted were her size. In the Bartlett bedroom, there were no fingerprints, no DNA, no threads, no fibers, no shoe prints, nothing to suggest that anyone other than the defendant was there. This defendant was the only one present in the room because she murdered her husband. This brings me to my third point. This defendant's motive. On July 3rd of 1996, the defendant and Martin Bartlett signed a prenuptial agreement. An agreement stating that, in the case of divorce, this defendant would not be entitled to a single penny of Martin Bartlett's net worth. But just 2 days later, Martin Bartlett signed his last will and testament, a document promising the defendant $71.4 million with no strings attached. But this promise was only possible if Martin Bartlett died before the defendant did. Faced with the threat of a divorce that would leave her with nothing, and with $71.4 million to gain from her husband's death, this defendant took matters into her own hands, and she murdered her own husband. Her print, her presence, and her motive. At the end of this trial, I'll come before you again, and together we will review all of the evidence that you will see and hear today. I'll ask you to find the only verdict consistent with the evidence, consistent with the law, and consistent with your own common sense. Find the defendant guilty of murder in the first degree. Thank you.
Thank you. Counsel for defense, do you wish to give an opening statement at this time?
Yes, Your Honor. May I have a moment to adjust my camera?
Yes. Proceed when you're ready.
May it please the court. The evidence left the scene because the killer left the scene. It's 1998, and Detective Concannon is standing on a street blocked off by yellow police tape. She's scratching her head at a loss. Her entire team is at a loss. Because Detective Concannon and her team have searched everywhere that Ms. Bartlett could have gone the night before. In the detective's own words, she's left no stone unturned. But after following every potential lead, Detective Concannon hasn't found a gun. Members of the jury, you'll learn that Ms. Bartlett did not have a gun in any of these places because the evidence will show she did not shoot anyone. You'll learn that the police searched exhaustively everywhere she could have gone the night before, everywhere she had time to go. That if she hid it, they would have found it. But they never did. You'll learn the evidence left the scene because the killer left the scene. Today, I represent Elizabeth Bartlett. Ms. Bartlett was 28 years old when her husband was murdered in front of her by an armed burglar. The government, at the very beginning of their opening statement, already brought up the age difference between Ms. Bartlett and her husband. So, members of the jury, I'll just say what we're all thinking. It's unusual. We all make assumptions about May-December couples. But here's what the government did not tell you about Elizabeth Bartlett. She is not a violent person. You'll learn today that she has no convictions for violent crimes, no reputation for violence, that she's never been accused of violence apart from this occasion. Now, as the defense, it's not my job to prove Ms. Bartlett's innocence. The government alone has the burden of proof, the highest burden in our criminal justice system, proof beyond a reasonable doubt. You'll learn today they can't meet their burden because their case is missing three types of evidence: forensic evidence, physical evidence, and witnesses. Let's take those one at a time, starting with the missing forensic evidence. Today, the government will tell you that Ms. Bartlett put a gun to her husband's head, pulled the trigger, and got no blood on her shirt, pants, hair, arms, or anywhere else on her body. You'll learn, they'll tell you that she did that and got no gunshot residue on her shirt, pants, hair, arms, or anywhere else on her body. Now, if the government argues today, well, maybe she washed it off, you'll learn they didn't find a drop of water on a shower wall, shower floor, bathtub, bathroom floor, that no wet towels, that her hair was dry. If they say maybe she got rid of her shirt and pants, we'll ask you where. Because you'll hear a list of everything the government found in their exhaustive search. You won't hear about a shirt and pants covered in blood and gunshot residue. If they say, hey, we found a pair of gloves, we'll ask you whose. Because you won't hear a single piece of DNA evidence to link those gloves to Miss Bartlett. Not a single hair strand, skin cell, not a single drop of sweat. That leads us to the second type of evidence that's missing from the government's case: the physical evidence. Today, you'll learn that even now, even after 26 years, the government still hasn't found the missing gun, the missing shirt, or the missing pants. You'll learn they also haven't found Mr. Bartlett's missing watches. They haven't found the rest of the jewelry. They haven't found cash that was stolen from the home. Throughout this trial, pay close attention to the government's excuses for this missing evidence, because you'll learn they searched everywhere they thought she could have put it: the house, the grounds, the pools, the tennis courts, the trash, the neighbor's trash. Everywhere they thought she could go, they searched. But they found nothing. The evidence will show those items were gone because the killer was gone. Now, the third type of evidence missing from the government's case are witnesses. Today, it will be undisputed that no one saw Ms. Bartlett do any of the things she's accused of. On New Year's Eve, the day when the greatest number of people are out after midnight, no one saw Ms. Bartlett running around the neighborhood with bloody clothes, watches, jewelry, cash, and a gun. You'll learn today that eyewitnesses aren't even the only type of witness the government's missing. The government told you in their opening statement about their fingerprint evidence, but members of the jury, that will all be quoted to you from written reports. The only expert you'll hear from today is ours. And she'll tell you that the fingerprint on that shell casing, it's not a conclusive match with Ms. Bartlett. Now, throughout this trial, think carefully about these three types of missing evidence. Because if the government hasn't found the missing evidence by the end of this case, if they've left you as lost as Detective Kincannon, then I'll ask you to find that the evidence left the scene because the killer left the scene. I'll ask you to find Ms. Bartlett not guilty. Thank you.
Thank you, Counselor. Would the government like to call their first witness, please?
Yes, Your Honor, but before I call my first witness, the government would like to read stipulation number 2 into the record.
You may proceed.
Stipulation number 2 states, as of January 1st of 1998, Martin Bartlett's net worth was $71.4 million. At this time, the government calls Deputy Commissioner C.J. Concannon to the stand. May I proceed, Your Honor?
May.
Good evening, Deputy Commissioner. I'd like to talk about your work in law enforcement. How long have you been in law enforcement?
Since 1984.
What is your current title?
I am a deputy commissioner with the Philadelphia Police Department.
Before that, what other titles have you held?
Captain of the Homicide Division, lieutenant, sergeant, and detective, which is the title that I held during this case.
Have you ever received any specialized police training?
Yes, I have training in crime scene preservation, ballistics, and interrogation.
Let's discuss your observations on the night of January 1st of 1998. Were you working that evening?
Yes, I was.
Directing your attention to 2:30 a.m. that night. What, if anything, happened then?
I received a call of a reported homicide at 1200 Dragon Drive in Ardmore, Pennsylvania. I reported to the scene immediately, and I met Miss Elizabeth Bartlett at the front door. She let me in.
Do you see Elizabeth Bartlett in the courtroom today?
Yes, I do.
Please identify her by an article of clothing.
She's wearing a pink blouse and a blue suit.
Let the record reflect that the witness has identified the defendant.
Any objection?
No objection.
Record will so reflect.
Deputy Commissioner Concannon, what happened when you walked inside the Bartlett home?
I went to the bedroom with our emergency medical technicians, and I saw Martin Bartlett's dead body.
Please describe what you saw in the bedroom.
Well, Martin Bartlett's body was on the right side of the bed. He was tucked under the covers. There was a bullet wound in his head, and he had blood under his nose. He was dead when we arrived.
Now, according to what is in evidence as Exhibit 3, which is the autopsy report, what was Martin Bartlett's cause of death?
A single gunshot wound to the head from a .22 caliber bullet.
Directing your attention now to your investigation after Martin Bartlett was pronounced dead. What, if any, evidence did you recover from the bedroom?
I recovered a box of 50 .22 caliber bullets with one bullet missing from the box, so there were only 49.
Objection, lack of foundation as to her knowledge that the box contained 50 bullets.
You wish to be heard?
Yes, Your Honor. It's my understanding that this witness was the lead detective on this case, and she established that the box contained 50 .22 caliber bullets, that she investigated and recovered that the box of 50 .22 caliber bullets, and she counted them and will testify to that. So she can establish that there were 50 .22 caliber bullets in there and that there was one missing.
Overruled.
Deputy Commissioner Concannon, I'll re-ask my question. What, if any, evidence did you recover from the bedroom?
I recovered a box of 50 .22 caliber bullets. I counted the bullets inside, and there were only 49. There was one bullet missing from the box. We also recovered a .22 caliber shell casing from the floor. It was underneath the nightstand of Martin Bartlett.
Did there come a time when you learned whether there was a gun inside the home?
Yes. During my investigation, I learned that Martin Bartlett owned a handgun.
Your Honor, I'm now showing Exhibit 10, which has been pre-admitted. Please describe the shell casing on the screen.
It's a .22 caliber shell casing, which is the same kind as the one that was found in Martin Bartlett's brain during the autopsy.
Are you aware of whether the shell casing was ever tested?
Yes, we tested it twice, actually, once in 1998 and again in 2022.
What happened when the shell casing was tested in 1998?
In 1998, we tried to see if we could find any prints on it, but we were unable to do that.
What happened when the shell casing was tested in 2022?
In 2022, we tested the shell casing with electrostatic fingerprinting, a technology that didn't exist in 1998. This testing revealed a fingerprint that was a 20-point match with the defendant's right index fingerprint.
I'm now removing Exhibit 10 from the screen. Deputy Commissioner Concanon, what, if any, other evidence was recovered as part of your investigation?
We found a pair of black leather gloves.
Where did you find those black leather gloves?
We found them in some bushes in a park nearby, about 100 yards from the home.
Your Honor, I am now sharing what's been pre-admitted as Exhibit 10. Deputy Commissioner Concanon, please describe the gloves that you recovered.
They're a women's size small, expensive gloves in almost perfect condition, but it looks like there was some
Objection,
blood.
lack of foundation as to her knowledge that the gloves are expensive.
I'm sorry, Counselor, could you restate your objection? I couldn't catch that. I apologize.
My apologies. There's no foundation as to the witness's knowledge that the gloves are expensive. I'm just objecting to the word expensive.
Overruled.
Deputy Commissioner Concanon, please describe the gloves that you recovered as part of your investigation.
Yes, they're a pair of women's size small, expensive gloves found in almost perfect condition, but it looks like there was some blood on them.
Was the substance that looked like blood ever tested?
Yes, it was.
What was the result of that test?
Those gloves tested positive for Martin Bartlett's blood.
I'm now removing Exhibit 8 from the screen. Did there come a time when you spoke with the defendant about what happened to Martin Bartlett?
Yes, ma'am.
What did she say?
She said that a burglar broke in and shot her husband in the head.
Did the defendant say at what time this happened?
She told me it happened after 2 a.m.
According to what's in evidence as Exhibit 3, which is the autopsy report, when was Martin Bartlett killed?
Between 12 and 12:30 a.m., almost 2 hours earlier than when the defendant had told me.
What, if anything, did the defendant tell you about where she was when this happened?
She said she was in bed next to her husband.
How did the defendant describe this burglar that she told you about?
She said he was 6'3" and he was wearing gloves.
What, if anything, did the defendant say about the gloves that we just looked at in Exhibit 8?
She admitted that they were her size, but she denied that they were hers.
Did there come a time when you tested the defendant's hands for gunshot residue?
Yes, ma'am.
What is gunshot residue?
It's an indicator that something or someone was either within 5 feet of or held a gun that went off in the last 48 hours.
What was the result of the gunshot residue test?
There was no gunshot residue on Elizabeth Bartlett's hands.
Were the gloves in Exhibit 8 ever tested for gunshot residue?
Yes, ma'am.
What was the result of that test?
They tested positive for gunshot residue.
Shifting your attention to what else you learned from this case. During your conversation with the defendant, what, if anything, did she say about the state of her marriage?
She said that Martin Bartlett had hinted at the possibility of divorce, but she claimed that they were doing well.
Your Honor, I'm now sharing my screen with what's been pre-admitted as Exhibit 6 and what is constructively removed from the jury's screen as Exhibit 7 for identification.
Right.
Deputy Commissioner Concanon, according to what is in evidence as Exhibit 6, which is the prenuptial agreement, what is the effect of divorce on the defendant?
She gets nothing, no spousal support.
Now I am directing your attention to Exhibit 7. Do you recognize this?
I do.
What do you recognize Exhibit 7 to be?
This is Martin Bartlett's will.
How do you recognize this to be Martin Bartlett's will?
I reviewed it during my investigation.
Is Exhibit 7 a fair and accurate representation of how it appeared on January 1st of 1998, or when you were shown it during the course of your investigation?
Yes, ma'am, it is.
At this time, the government moves what's been pre-marked as Exhibit 7 for identification into evidence as Exhibit 7.
Any objection?
Yes, Your Honor. Objection under Rule 104B. The relevance of this will is conditional on the fact, on the issue of whether Ms. Bartlett had actually seen the will or was aware of the will's contents before Mr. Bartlett was murdered, and no evidence has been elicited as to that issue.
Your Honor, may I be heard?
Yes.
Your Honor, the probative value of this document is not substantially outweighed by the prejudicial effect, and whether or not Elizabeth Bartlett, the defendant, was aware of the contents of the will is not at issue here today. The document has...
What is the probative value of this will then, if it's not that?
The probative value is the defendant's motive. Having been married to Martin Bartlett, and the fact that this will was signed just 2 days after the fact, as listed on Exhibit 7, and comparing it to Exhibit 6, it's signed 2 days after the prenuptial agreement was signed, 1 day after the marriage. This is entirely relevant to the defendant's motive, which is relevant to proving her intent to kill Martin Bartlett, because she was aware that there was a divorce that had been put on the table by Martin Bartlett in December of 1997, and because of that, this goes to her motive to kill him.
Do you have anything further, counsel for defense?
Yes, I wasn't raising a 403 objection. I was raising a 104B conditional relevance objection. I'm not disputing that the will has no bearing on motive. I'm saying the relevance of the will toward motive is conditional on a fact that the government hasn't proven or shown evidence for, which is that Ms. Bartlett actually had some awareness of this will.
Your Honor, may I be heard?
Specifically as it relates to laying the proper foundation that is as he's outlined in his objection, I believe clearly.
Yes, Your Honor. So if I may proffer, this witness will soon testify to the fact of his conversation, or her conversation, excuse me, with the defendant regarding the will as well as the prenuptial agreement, and what the defendant's response was to the conversation about the will, and the detective's observation of the defendant when they had this conversation.
All right, I'm going to overrule the objection.
Yes, Your Honor.
Your Honor, permission to publish Exhibit 7 to the members of the jury at this time?
Yeah.
Deputy Commissioner Concannon, did you review Martin Bartlett's will?
Yes, I did.
Based on your review of the will, what is the effect of divorce on the defendant's inheritance?
There is no effect. The defendant would inherit Martin Bartlett's entire fortune, which was approximately $70 million.
And during your conversation with the defendant, did there come a time when you spoke about Martin Bartlett's will?
Yes.
What, if anything, did the defendant say?
She just immediately denied that she was having an affair and said she had no fears of divorce.
Please describe the defendant's demeanor when you discussed Martin Bartlett's will with her.
She didn't seem surprised or shocked at all.
I'm now removing Exhibit 6 and Exhibit 7 from the screen. No further questions, Your Honor.
All right, defense counsel, do you wish to cross at this time?
Yes, Your Honor. Commissioner, can you see and hear me okay?
Yep.
I want to start with some of the information you did not share about Elizabeth Bartlett. You made a thorough investigation, right?
Yes, sir.
When you investigated Ms. Bartlett, you found no convictions for violent crimes?
That's correct.
No reputation for violence?
That's correct.
She was 28 then, right?
That's correct.
She's in her 50s now.
I believe so, yes.
Apart from this occasion, you haven't heard a single accusation of violence against her?
No, sir.
Let's talk about whether Ms. Bartlett was the shooter. Now, in the words of your own department's forensics report, there's no way to determine with certainty that the gun that shot Mr. Bartlett was actually a Ruger 22, right?
That's correct.
You said on direct examination that the Ruger 22 was the gun that Mr. Bartlett owned, right?
That's correct.
Your forensics department said that multiple makes of handgun could have fired that bullet, right?
That's correct.
Now, that fingerprint that the lab found on the shell casing, you said on direct examination that it came from a right index fingertip?
Yes, sir, I did say that.
And that print from the right index fingertip was the only print that the lab found on the whole shell casing?
The only identifiable print, yes.
Well, let's be clear. The lab didn't find unidentifiable prints, right?
The right index finger was the only identifiable print we found.
That wasn't my question. My question was that the lab found no other prints that they could not identify, right?
Not that I'm aware of.
So the lab found no thumbprint on the shell casing, right?
Nope.
The lab also found none of Ms. Bartlett's fingerprints on that box of bullets in the bedroom, right?
That's correct.
Didn't find a speck of gunshot residue on Ms. Bartlett's nightgown, right?
That's correct.
Or on her body.
That's correct.
Didn't find a drop of Mr. Bartlett's blood on her nightgown, right?
That's correct.
Or on her body.
That's correct.
You found no evidence that she washed it off, right?
That's correct.
Now let's talk about whether that autopsy report is reliable. The autopsy report places the time of death between 12 and 12:30, is that right?
Yes, sir.
Now, you didn't conduct the autopsy, right?
No, but I attended it and I reviewed it.
So that's a yes that you did not conduct the autopsy?
That's correct.
The coroner conducted the autopsy, right?
That's correct.
In 1998, right?
That's correct.
Using methods from 1998?
That's correct.
Science from 1998?
That's correct.
Now, you can't tell me if any of the methods that the coroner used in 1998 are still accepted today, right?
That's correct.
Now, the autopsy report says that the human body, that a dead body rather, loses 1.5 degrees of temperature per hour, right?
That's correct.
You can't tell, and the coroner used that number to calculate the time of death?
That's correct.
Commissioner, you can't tell me if that rate of temperature drop is accelerated with blood loss, right?
Objection, Your Honor.
Grounds.
This is outside the scope of the witness's knowledge. She's not a medical examiner.
Defense.
Your Honor, the witness is testifying as to the contents of the autopsy already. Also, per the pretrial order, the witness, specifically Commissioner Concanon, is stipulating as being allowed to testify to any of the contents of the autopsy and forensics reports without foundational issues or 702 objections.
Overruled.
I'll ask again, Commissioner, you cannot tell me if blood loss accelerates the rate that the body loses temperature.
No, I can't say that.
Let's talk about whether Ms. Bartlett hid evidence. Now, when you investigated You determined that Mr. Bartlett's expensive watches were missing, right?
Correct.
You determined that Ms. Bartlett's jewelry case was empty, right?
That's correct.
You found no cash in the bedroom, right?
That's correct.
You also said that Mr. Bartlett's gun was missing, right?
That's correct.
Now you searched for the evidence, right?
Yes, sir.
You searched the house,
Yes, sir.
the yard,
Yes, sir.
the tennis courts,
Yes.
the pools.
Yes.
You searched the public park, right?
Yes, sir.
The trash,
Yes, sir.
the neighbor's trash.
Yes, sir.
In your own words, you left no stone unturned.
That's correct.
Now, you never found a shirt with blood and gunshot residue on it, right?
Nope.
You never found pants with blood and gunshot residue on it.
No.
You never found Mr. Bartlett's watches, right?
No.
You never found the rest of the missing jewelry.
No.
You never found cash.
No.
Commissioner, you never found a gun.
That's correct.
No further questions.
Redirect.
Yes, Your Honor, briefly. Deputy Commissioner Concanon, I'd like to talk a bit more about your investigation in this case. Did there come a time when you followed up on any potential leads?
Yes, obviously, I followed all potential leads and conducted all appropriate searches and investigations. I left no stone unturned.
In the Bartlett's bedroom specifically, what, if any, forensic evidence pointed to a third party?
No evidence recovered pointed to a third party in the Bartlett's bedroom. No footprints, no threads, no DNA, nothing.
No further questions, Your Honor. I ask that this witness be permitted to step down constructively, barring no recross.
Counsel for defense, do you have a recross?
No recross, Your Honor.
All right. The witness is excused. All right. Government, you may call, counsel for the government, you may call your next witness.
Your Honor, the government rests its case.
All right. I'm told in this jurisdiction we have no mid-trial motions. So do we proceed directly to the defense's case in chief?
Defense is ready, Your Honor.
All right, let's proceed. Why don't you call your first witness, please?
Yes, Your Honor. Defense calls Ms. Sam McGarry.
All right, Sam McGarry, you're under oath.
You may take a quick sip of water. May I proceed?
You may.
Ms. McGarry, can you see and hear me okay?
Yes, I can.
Please introduce yourself to the jury.
Hi, my name is Sam McGarry.
What do you do for a living?
I'm a forensic scientist.
How are you involved in this case?
I was asked to evaluate the newly discovered electrostatic fingerprint evidence on the shell casing that was discovered at the crime scene.
Were you asked to determine if that evidence was reliable?
Yes, I was.
And before we get into your conclusions, I want the jury to get a sense of your credentials. What degrees do you hold?
I have a master's in forensic science from UC Irvine, and I have bachelor's degrees in biology and chemistry, also from UC Irvine.
Are you part of any forensic science organizations?
Yes, I'm a member of the National Criminologists Association, as well as the American Association of Forensic Examiners.
Have you ever worked in a police forensics lab?
Yes, I worked for the San Diego Police Department CSI unit for 6 years.
And in your 6 years in the CSI unit, how many cases did you investigate?
Hundreds.
Where did you go after the CSI unit?
After I worked at the CSI unit, I joined the Innocence Project as a forensic expert.
What did you do as a forensic expert with the Innocence Project?
I tested or retested evidence that was originally evaluated by state and federal forensic technicians.
Are you still at the Innocence Project now?
No, I was lucky enough 8 years ago to start my own forensic consulting practice.
What do you do as a forensic consultant?
I provide forensic expertise to criminal defendants.
Ms. McGarry, I want to be upfront with the jury. Did you charge a consulting fee to work on this case?
Yes, I charged my standard rate of $50,000 with an additional $20,000 if I'm called as a witness at trial. I also charge lab costs for my own electrostatic fingerprinting analysis tests of the shell casing.
Before you started your forensic consulting practice, how many times did you testify as an expert witness?
86 times.
Your Honor, defense tenders Ms. McGarry as an expert in forensic science.
Counsel for government, do you have a position on that?
No objection, Your Honor.
This witness will be received as an expert in what was what field of specialty?
Forensic science.
All right, I'm sorry, I didn't hear that. All right, you may proceed.
Let's talk about how you formed your conclusions, Ms. McGarry. What materials did you review?
I reviewed the shell casing that was recovered at the crime scene. I also reviewed a transcript of a prior legal proceeding, and I reviewed the FBI's forensic report written by Dr. Hayes.
Did you run any electrostatic fingerprinting tests?
I did.
What did you test?
I tested the shell casing that was recovered at the scene, and I found one usable print.
Now, you said one usable print. What's the difference between a usable print and an unusable print?
Some prints found at crime scenes can often be damaged or smudged. This makes them unsuitable for fingerprint comparison analysis, so we call these unusable prints.
Did you find any damaged prints on the shell casing?
No, I didn't.
Smudged prints?
None of those either.
Now, this one print that you found, did you compare it to Ms. Bartlett's prints?
I did.
How?
I looked for points of similarity, like Dr. Hayes did for the government, and then I conducted my own analysis and ran the prints through the Landingham computer scan.
Do experts in your field usually rely on these methods?
Yes, they do.
Let's talk about your conclusions. Now, the government's forensic report alleges that Ms. Bartlett may have wiped fingerprints off the shell casing. In your expert opinion, is that true?
In my opinion, there's no way to determine that.
Well, the government also alleges that the fingerprint on the shell casing belongs to Ms. Bartlett. In your expert opinion, is that true?
No, because we don't know that either.
Well, let's talk about why not. And I want to start with the wiping first. Why can't we be certain that Ms. Bartlett was the one who wiped the shell casing?
It's simply not how fingerprint analysis works. There's no way to determine, first of all, when a fingerprint was made on a surface, so there's also no way to determine if someone wiped the object, let alone who did it or when.
Well, when was the shell casing collected for evidence?
That would be 1998.
When did the government do their electrostatic testing?
2022.
Is that 24-year gap significant?
I believe it is.
Why?
The police had that shell casing for 24 years before it was tested. That's a long time to avoid contamination, especially for a piece of evidence that law enforcement had already determined to not contain trace evidence.
Now, Ms. McGarry, I want to talk about whether that one print on the shell casing actually belongs to Ms. Bartlett. So first of all, what does it mean to look for points of similarity on fingerprints?
Every fingerprint has unique patterns. So when experts look for points of similarity, they're looking for spots where those patterns match.
Are you aware that the government's forensic report says that there's 20 points of similarity on the fingerprint?
Yes, that was the FBI's finding.
Is that accurate?
No, I don't believe so. I found only 8.
I want to be clear about what that means. Do some law enforcement agencies consider 8 points of similarity to be enough to declare a match?
Only some of them do. Other agencies require a minimum of 12 points to declare a match.
Why is there disagreement among law enforcement about the minimum number of points to declare a match?
Unfortunately, fingerprint analysis is not as precise as other kinds of forensic evidence, like DNA. With fingerprinting, there's no universal standard for the minimum number of points to declare a match.
Have fingerprint experts ever made mistakes?
Yes, unfortunately, they have. There have been dozens of cases where fingerprint errors weren't discovered until after a jury verdict.
You mentioned you also used computer software to compare the fingerprints. What was the result of that comparison?
The Landingham scan found only an 83% probability that the fingerprint on the shell casing came from Miss Bartlett.
Now, why do you say only 83?
Well, because of that remaining 17%.
What do you mean by that?
Well, like I said, fingerprint evidence is not as precise as other types of forensic evidence like DNA, and it's not a flawless science. So, in my opinion, I cannot ignore that 17%.
No further questions.
Cross-examination.
Yes, Your Honor. But before I begin my cross-examination, I'd like to read pretrial order 12 into the record.
You may.
At all times, law enforcement agencies have maintained uninterrupted custody over the shell casing in Exhibit 10. May I proceed, Your Honor?
May.
Ms. McGarry, let's talk about some of the reports in this case.
Sure.
You reviewed Dr. Emily Hayes' forensic report from 2022, correct?
Yes, I did.
You're aware that she performed electrostatic fingerprinting on the shell casing in Exhibit 10.
That's correct, she did.
Your Honor, permission to utilize a demonstrative to aid the jury's understanding of the witness's testimony?
Is it a whiteboard? Is that what you're using?
It's a T-chart, Your Honor.
Okay. No problem. Any objection?
No objection.
All right.
Let the record reflect that I have created a T-chart with Dr. Emily Hayes' report on the left column and Sam McGarry's report on the right column. I'm now adding performed electrostatic fingerprinting on shell casing to the left column. Mrs. McGarry, electrostatic fingerprinting is a peer-reviewed forensic technique.
That's correct. It's been peer-reviewed in the last 16 years since it was discovered.
And it's been accepted as reliable.
Generally, yes. It has its skeptics because it's still quite new.
But bringing you back to my question, it has been accepted generally as reliable.
That's correct.
directing your attention again to Dr. Hayes's report. You're aware that she found a single print on the shell casing in Exhibit 10, correct?
That's right. She also found one usable print on the shell casing.
I added one fingerprint on shell casing to the left column. You also performed electrostatic fingerprinting for the shell casing, correct?
That's right.
Adding performed electrostatic fingerprinting on shell casing to the right column. Mrs. McGarry, you also found one fingerprint on the shell casing.
That's right. I also found one usable print.
Adding one fingerprint on shell casing to the right column. Mrs. McGarry, when Dr. Hayes conducted her electrostatic fingerprinting test, she found a 20-point match from that one fingerprint on the shell casing to the defendant's right index fingertip, correct?
That's right. She claims to have found a 20-point match.
I've added 20-point match to the left column. You also concluded that there was an 8-point match to the defendant's right index finger on the shell casing, correct?
That's right. When I ran the same analysis, I only found 8 points of similarity.
I've added 8-point match to the right column. Your Honor, permission to preserve this demonstrative and label it as a government's Exhibit A for identification throughout summation.
That's fine.
Thank you, Your Honor. I'm now removing government's demonstrative Exhibit A from the screen. Mrs. McGarry, you didn't stop after performing your electrostatic fingerprinting, did you?
What do you mean by that?
Well, you decided to do another test of the shell casing.
That's right. I used the print I was able to find through electrostatic fingerprinting and ran another analysis.
Right, that analysis that you ran was called Lanningham Computer Technology.
That's the technology I used, yes.
And that technology is highly reliable.
Absolutely.
That computer scan found an 83% probability that the fingerprint came from the defendant's right index finger.
That's right. It found only an 83% probability.
And we can agree that computer identification has become extremely reliable, hasn't it?
That's right. We use computer identification for daily tasks all the time, like unlocking our phones.
Mrs. McGarry, isn't it true that you have no qualms with Dr. Hayes's methods?
Absolutely. I have no problems with how she conducted her tests or her methods.
In fact, it's your opinion that Dr. Hayes correctly performed electrostatic fingerprinting on the shell casing in this case.
Absolutely.
Let's talk now about your relationship with the defendant.
Sure.
You've testified as a forensic expert before.
Yes, many times.
And since opening your own office, you've only ever testified for the defense.
That's correct. Governments already have their own forensics teams, so independent forensic examiners work for criminal defendants.
Right, but to be clear, you've only ever testified for the defense since 2015.
That's correct.
And of all the expert reports that you've provided, those have all been for the defense.
That's correct, yes.
You were retained by the defendant's lawyer here today
Yes, that's right.
to evaluate the new fingerprint evidence reported on by Dr. Emily Hayes.
Precisely. I was asked to give a second opinion.
For your second opinion that you provided, you only reviewed 3 exhibits in this entire case.
Well, that's correct. The print was on the shell casing, so I reviewed the shell casing. I also reviewed the report that I was asked to give a second opinion on, and I reviewed the transcript from the 1998 proceeding.
You had a brief conversation with Dr. Emily Hayes, correct?
That's right. I wanted to make sure I understood how she conducted her test.
You had another brief conversation with defense counsel.
Precisely, to get a brief idea of the case.
Not once did you speak to anyone else involved in this case.
No, forensic examiners usually don't conduct interviews.
But as you stated on direct, you charged the defendant $50,000 for your work.
That's correct. That's my standard fee for an analysis.
And I'd just like to clarify something that you stated on direct examination. You didn't have to pay for your lab costs that were associated with your work in this case, correct?
That's correct. It's standard that the client pays in my field.
And for testifying here today, or after you're done testifying here today, you'll make another $20,000.
That's right. $20,000 is my fee for appearing in trial.
So to be clear, after the end of today's trial, you'll have made at least $70,000 for your involvement in this case.
That's right. That will be the total compensation for my work in this case.
You testified on direct examination about the contamination or possible contamination of the shell casing. Let's talk about it.
Sure.
When you say contamination, you mean that the shell casing was wiped by someone.
Not exactly.
Well, to be clear, you found no affirmative evidence of mishandling of the shell casing in this case.
I didn't find affirmative evidence of mishandling by law enforcement, but contamination is possible in a number of ways.
Well, contamination aside, when someone touches metal, like the shell casing, their fingerprint will permanently corrode it, correct?
It depends. If they're sweating, then the chloride ions in their sweat can cause permanent corrosion with metals like copper and brass, which is an alloy. Then we can use electrostatic fingerprinting to detect those patterns.
Wiping the metal won't change those corrosion patterns once they're created, will it?
That's right. If there's been corrosion, it can't be wiped.
And it won't get rid of them either.
That's correct.
Mrs. McGarry, to be clear, there was only one fingerprint that you found on this shell casing.
I found one usable fingerprint.
And it's your opinion that there is an 83% chance that that one usable fingerprint belongs to this defendant.
That's correct. The computer found an 83% probability that it was her print and 17% probability that it was not.
No further questions, Your Honor.
Redirect.
Yes, Your Honor. May I proceed?
You may.
Ms. McGarry, does electrostatic fingerprinting tell you whose fingerprint is on an object?
No, it can only help us to lift a usable print from a metal object.
Does electrostatic fingerprinting compare that print to other people's prints?
Not itself. Once we recover a print using electrostatic fingerprinting, then we use other methods of analysis to compare, such as a manual analysis or a computer analysis, which I did both.
No further questions. Thank you, Ms. McGarry.
Any recross?
No, Your Honor.
All right. May this witness be excused?
Yes, Your Honor.
All right. You may call your next witness, counsel for the defense.
Defense has no more witnesses. We're ready for closing argument.
All right. Counsel for the government, do you need a moment or are you ready to proceed with closing argument at this time?
I'm ready to proceed, Your Honor.
All right. Let's go ahead and do it.
Her print, her presence, and her motive. On December 31st of 1997, 67-year-old Martin Bartlett went to bed early. By 10 p.m. on New Year's Eve, Martin Bartlett was fast asleep. But this defendant was wide awake, waiting to carry out her plan. Right after 12 a.m., this defendant walked into the master bedroom. She grabbed a single bullet from a box of 50 .22 caliber bullets. She then grabbed her husband's gun, and she loaded that bullet. This defendant then walked right up to her husband, pulled the trigger, and shot him directly in the head. On January 1st of 1998, this defendant murdered her husband. And for 26 years, this defendant has gotten away with that murder. But you can change that. And now that you've seen the holes in her story and the results of fingerprint technology that was unavailable in 1998, you know that this defendant is guilty. At the beginning of today's trial, I came before you, and I explained that we, the government, have the burden of proof in today's case. We had to prove to you, beyond a reasonable doubt, that this defendant is guilty of murder in the first degree. And we've met our burden because of this defendant's print, this defendant's presence, and this defendant's motive. Which brings me to my first point. This defendant's print. The defendant wants you to believe that everything in this case is a coincidence. But look at the consistencies. This shell casing, as shown in Exhibit 10, was found on the floor next to Martin Bartlett's dead body. That's not a coincidence. It was the same caliber as the bullet lodged in Martin Bartlett's brain. The recovered box of bullets with just one bullet missing was consistent with this shell casing. It was consistent with the bullet that killed Martin Bartlett. What are the odds that a single bullet goes missing? And what are the odds that it's consistent with the one that killed her husband? What are the chances that Martin Bartlett's missing gun was capable of shooting the bullet that killed him? That his gun was capable of discharging this shell casing found right next to his dead body? None of this is pure happenstance. None of this is an accident. None of this boils down to coincidence. No, it is proof beyond a reasonable doubt. Back in 1998, no prints were found on that discharged shell casing. But 24 years later, Dr. Emily Hayes used electrostatic fingerprinting, and she found a single print. A print that was a 20-point match to this defendant's right index fingertip. Now, a shell casing isn't like a remote control for the TV or a doorknob to the front door, where you can understand why the defendant's fingerprint would be there. But why would she touch a shell casing? There's only one reason to do that, and it's to use it, to load it into a gun, and to kill someone. Keep in mind that the defense bears no burden here, but they chose to call an expert, Sam McGarry. And you need to evaluate her credibility just like you would anyone else. Because their expert was being paid $70,000. $70,000, and the best that their expert could do to cast a reasonable doubt on this defendant's guilt was admit that that one fingerprint on the shell casing shared points of similarity with the defendant, as shown in the government's demonstrative Exhibit A. That after using highly reliable computer technology, there's an 83% chance, probability, that the print came from this defendant. She didn't say that the print wasn't the defendant's or that there were other prints on the shell casing. No, their expert said that she had no qualms, no issues with Dr. Hayes' tests or her methods. She admitted that Dr. Hayes correctly performed electrostatic fingerprinting on that shell casing. But somehow, some way, she ends up with a different result? No, the result is the same. The only print found on that shell casing belongs to this defendant. And that's because she used that shell casing, that bullet, to kill her husband. Which brings me to my second point. This defendant's presence. On January 1st at 2:30 a.m., 2 full hours after Martin Bartlett was killed, Deputy Commissioner Concannon was notified. For 2 full hours, this defendant was the only one present in the bedroom with her dead husband. She had 2 full hours from when she shot and killed him to make up her story. 2 full hours to change her clothes, to ransack their bedroom, to leave the home and dump her gloves. But her story wasn't perfect. The defense wants you. No, they need you to believe that a burglar broke in and killed Martin Bartlett. But there were no unknown fingerprints in the home, no third-party DNA, threads, fibers, shoe prints, nothing found anywhere in the Bartlett's bedroom. There was absolutely no evidence to suggest anyone but this defendant was in the room when Martin Bartlett was killed. If the defendant was lying in bed with her husband when he was shot, like she said that she was, she should have blood and gunshot residue on her body. But when she was tested for gunshot residue, she tested negative. Why was that? Because she was wearing this pair of gloves as shown in Exhibit 8. This same pair of gloves that was found in a park 100 yards from her home. These same gloves that came back positive for gunshot residue and for Martin Bartlett's blood. These gloves aren't some 6'3" burglar's gloves. They belong to this defendant. And you know this because she had to admit that they were her size. Members of the jury, there is a 2-hour difference between the defendant's version of when Martin Bartlett was killed and what the evidence has shown to be true. And in those 2 hours, this defendant orchestrated the entire story that was presented to you today. And now you know that the evidence suggests that it was just that, a story. Because the only person present, the only person who knows what really happened on January 1st of 1998 is the one who stood to gain $71.4 million from killing her husband. Which brings me to my third point. This defendant's motive. 2 legal documents exist in this marriage. A prenup, as seen in Exhibit 6, which states that in the event of divorce, this defendant gets nothing. And a will, as shown in Exhibit 7, that says if Martin Bartlett predeceases the defendant, she gets everything. Just 2 days after signing their prenup, Martin Bartlett promised his entire fortune to this defendant. She was the sole beneficiary to his $71.4 million fortune. Excuse me. Absolutely and entirely to this defendant, his wife, who he considered divorcing. Why is that important? Because this defendant knew that her husband had threatened a divorce. She admitted to hearing him hint at one. And if that happened, she'd be left with nothing, not a single penny. But she knew that she'd get all of his money if he died. You know that this defendant was well aware of what she stood to gain from killing her husband. Think of her reaction when asked about his will. She didn't cry. She didn't scream. She wasn't surprised. She didn't say that she didn't care about the money, that she just wanted her husband back. No, she immediately denied having an affair. With $71.4 million to gain from killing him, this defendant had a motive, and she meant to kill Martin Bartlett because she had nothing to lose and everything to gain. With her print, her presence, and her motive, all of the evidence points right at this defendant. We ask that you find the only verdict consistent with the evidence, consistent with the law, and consistent with your own common sense. find the defendant guilty of murder in the first degree. Thank you.
Thank you. Defense counsel wish to give your closing argument now?
Yes, Your Honor. Just going to get set up.
Take your time.
Thank you. May I proceed?
Yes.
"26 years. That's how long the government's had to find the missing evidence. 26 years, and they're still scratching their heads. They're still at a loss. And why? Because they've only looked for the missing evidence where Ms. Bartlett could have hid it. They've only had her in the crosshairs. Their searches presumed she was guilty. But with every passing year that the missing evidence doesn't turn up in the neighborhood, it gets harder and harder for the government to deny that the evidence left the scene because the killer left the scene. Today, the government had to meet the highest burden in our entire criminal justice system: proof beyond a reasonable doubt. Now, what does that mean? Well, if you think it's possible that Ms. Bartlett shot her husband, you must find her not guilty. If you think it's likely, if you think, yeah, she probably did it, you still have to find her not guilty. Because the government has to convince you beyond all reasonable doubt. Today, the government's case had 3 sources of reasonable doubt: missing forensic evidence, missing physical evidence, and missing witnesses. Let's take those one at a time, starting with the missing forensic evidence. The government's own forensics today proved that Ms. Bartlett did not shoot anyone. It proved this because the government found not a speck of gunshot residue, not a drop of blood anywhere on her body, and they can't tell you why. They found no evidence that she washed it off. They found no evidence that she got rid of her clothes. The government talked today about the gloves they found, but we don't know whose gloves those are. They found not a single strand of DNA to link Ms. Bartlett to those gloves. And the size of the gloves proves nothing. They said, oh, Ms. Bartlett said that the burglar was tall. Okay. What condition was she in when she said that? She was woken up in the middle of the night by a man in a ski mask who shot her husband and threatened her at gunpoint. She thought she was going to die. How could she not be traumatized from that? In that state, how could she not remember her attacker as being bigger, scarier, more imposing than his actual real-life size? The government also said today that Ms. Bartlett lied about the time of death, that she had this 2-hour window to hide the evidence, which, by the way, they still haven't found. Members of the jury, we don't know what time Mr. Bartlett died. We don't know this because it is reasonable to doubt old science. Detective Kincannon took the stand today and admitted on cross-examination that she doesn't know if the methods used to calculate the time of death in that almost 30-year-old autopsy are still accepted in modern times. She said she doesn't even know if the methods were correct by 1998 standards. They used this temperature loss rate with no idea if blood loss makes you lose body temperature faster. We don't know when Mr. Bartlett died. See, when it suits the government, it's science has improved. Let's use the electrostasis. Let's use the fingerprint. But when it doesn't suit the government, it's, oh, you can trust us. The science hasn't changed at all for almost 30 years. They don't get to have it both ways. And speaking of questionable scientific conclusions, if there's no thumbprint on that shell casing, that's reasonable doubt. Because unless Ms. Bartlett is Spider-Man with superhuman sticky fingers, then she cannot pick up a bullet and load it into a gun using just her index fingertip. Remember, the index fingertip, that's the only print the government found on the shell casing. They were very clear about that. They even they even reinforced that in cross-examination. When they cross-examined our expert, you only found one fingerprint and our expert agreed. They even put that up in their demonstrative, the one fingerprint. Now, the government didn't use their imaginations today. They didn't say, they asked, how could there possibly be a fingerprint on a shell casing unless that person loaded the gun? There's another way that Ms. Bartlett's right index fingertip could have touched that shell casing. How do we know that she did not bump that shell casing out of the way by accident when she was rifling through her husband's watch collection on the nightstand to hand to an armed burglar? No thumbprint is reasonable doubt. Now, the government, their case today is built on a print and presence. We've disputed the print. Let's talk about the presence. You know what was not present at the crime scene? A gun, watches, the rest of the jewelry, bloody clothes, cash. In fact, the second type of evidence that's missing from the government's case, the second source of reasonable doubt, is the missing physical evidence. See, if the government hasn't found a gun, then they haven't found the killer. Because they searched everywhere that Ms. Bartlett could have hid that evidence. And if the evidence was nowhere that Ms. Bartlett could have hid it, then the conclusion is that she did not hide it. That someone else took it out of the neighborhood. That the evidence left the scene because the killer left the scene. Now, the third source of reasonable doubt in the government's case today are the missing witnesses. Today, it was undisputed that no one saw Ms. Bartlett running around the neighborhood, hiding evidence, wearing bloody clothes, holding a gun, cash, watches, jewelry. No one saw her. At midnight, just after midnight, according to the government, on New Year's Eve, no one saw her in the public park. No one saw her trespassing on neighbors' properties, putting things in their trash cans. See, according to the government, Ms. Bartlett is not only Spider-Man who loads bullets with her fingertips. She's not only a magician who makes evidence disappear for 26 years. Now, she's also a ninja with super stealth abilities who can sneak through the neighborhood at the most crowded, the most active time of the New Year's Eve holiday, undetected. You didn't hear from a single witness today who saw her. You didn't hear Detective Concannon say they got any reports of a car speeding through the neighborhood, of a person trespassing on neighbors' properties. You heard nothing. That's reasonable doubt. Members of the jury, the government wants you to take the same closed-minded view that's led them to no answers in 26 years. To look at the missing gun, to look at all the missing evidence, and shrug your shoulders, say, whatever, at least we have gloves. They want you to look at Miss Bartlett and say, I know what kind of person she is. The type of person who kills for money. Today you found out what kind of person Elizabeth Bartlett is. She's the kind of person who their own arresting officer admitted had no history of violence, no reputation for violence, never been accused of violence. That's why the evidence was nowhere that Miss Bartlett could have hid it. That's why the evidence left the scene. Because the killer left the scene. That's why you must find Elizabeth Bartlett not guilty. Thank you.
Do you have remaining time for rebuttal, counsel for the government?
I believe so. I'd ask that the timekeepers confirm that.
According to my math, Ms. Duran has time for rebuttal.
All right, you may proceed.
Thank you, Your Honor. The evidence left the scene because the killer left the scene? No, the evidence did not leave the scene. In fact, it was found right under Martin Bartlett's nightstand, right next to his dead body. The shell casing that pointed only at this defendant. It was found 100 yards from the home, in some bushes. The bloodied gloves covered in gunshot residue. It was found in the bedroom, right where this defendant was. Now, I'd like to talk about defense counsel's arguments and the holes in them. Defense counsel spoke about missing forensic evidence. But you're aware that a pair of women's small gloves was found in just 100 yards from the home. A pair of gloves that this defendant admitted were her size. So when her story was that a 6'3" burglar broke in and murdered her husband, obviously, when she admits that those are her size, they belong to her. Use your common sense. What 6'3" man do you know that wears women's size small gloves? The shell casing that Mrs. McGarry admitted had an 83% probability of coming from the defendant. That shell casing that Mrs. McGarry admitted, that was an 8-point match. She admitted that. An 8-point match when some law enforcement jurisdictions only require 6. So Mrs. McGarry just told you that somewhere this defendant would be found guilty. Let's talk about the missing physical evidence that defense counsel brought up. The reason that no guns, no watches, no bloody clothes were found was because this defendant created the entire story presented to you today in those 2 hours between when she claimed Martin Bartlett was killed by a burglar and what the time of death on the autopsy report established. They're asking you to trust the word of a woman with $71.4 million to gain from killing her husband. A husband who threatened her with divorce. He threatened to leave her. And that divorce would leave her penniless. You know that Deputy Commissioner Concannon admitted that she followed up on all potential leads in this case and found nothing pointing to anyone else. The defense is asking you to focus on that lack of evidence pointing to anyone else. but we're asking you to consider the evidence presented to you today. Let's talk about the missing witnesses defense counsel raised. No one saw the defendant running around the neighborhood because it was New Year's Eve at midnight. Members of the jury, what are you doing on New Year's Eve at midnight? You're watching the ball drop. You're celebrating with family and friends. You're giving them hugs. You're giving them kisses. You're not looking out your window. So of course no one saw her. They were too preoccupied with bringing in the new year. Her print, her presence, and her motive. 26 years later, you know that you have an answer. Find the defendant guilty of murder in the first degree. Thank you.
Excuse me. All right, thank you very much. We have, I believe, an opportunity for the scoring judges to give critique. I believe it's, that's what I read on the rules. I'm not sure if I can be corrected on that.
I will not correct you, Don. You did read it correctly. However, why don't we just wait for the 3 ballots to come in? And as soon as I can confirm that I have them, I'll let you guys get going with that. I will also add to the advocates, please don't leave the Zoom room. We're going to announce the winner of the competition right here in this Zoom room, so do not leave. I'll sign back on when all 3 ballots are in.
Should I turn the video off and whatnot?
Whatever you want to do is fine with me.
All right.
Okay, we have all the ballots. So Don, Michael, and Roz, you guys can give some brief comments, and as soon as we're done with that, we will announce the winner.
All right. I'll go ahead and let the scoring judges go ahead and introduce themselves and give brief comment. Do we have our scoring judges on? Or oh, there we are. Okay. Let's say I believe Mr. Kaplan. Do you have a few comments?
Very, very few, because the competition was really intense. I thought that both sides presented great arguments in a case. Um, I, I think maybe there was some gaps in terms of what could have been argued in terms of the case, but both teams presented great arguments, and there's nothing at this point I can tell you other than to go by the result of what you have. I just have a very strong suspicion that it was a very close contest.
All right, and our other scoring judge, please.
Yeah, hi. I thought both of you were superb advocates, and what was interesting to me is you have totally different styles. And it proves the point that there's more, it's a horrible expression. I have my cat sitting in here. There's more than one way to skin a cat, and you have to be who you are, and you can't try to be somebody else. Katie, you are understated, quiet, firm, but very controlled and effective. And Nathan, you're more going for the jugular. And my comment to you might be not that you shouldn't go for the jugular, because I think it's effective, but in terms of your tone, maybe vary it up a little bit. I don't know if you've heard that before, but you want to change your tone with your witnesses. I thought your opening was very striking, and the tone of it was a bit like a closing. So I would think about that. But I thought your themes carried through, both of you. Obviously, you had different themes, but I thought they carried through really well with all your witnesses, and with your closings. You were both able to hearken back to your openings and your closings, which is the goal. And I don't know where either of you attend law school, but you did what's very effectively done in these competitions. And I have a hunch who the originator of this theory is there's 3 points that I want to make, and you both did that extremely well. 3 totally different points, but they stuck in my mind throughout.
All right. Thank you. And I'll just add, along with everything else that was said, those were 2 very high level performances. You should be very proud of that. I imagine I'm a coach as well. And I wasn't in this competition, but this was both your coaches will be very proud of your performances, because it was high level. I felt like the directs and crosses all scored very well in terms of getting the points you wanted across. And it was interesting. It was completely different styles. And Katie and Nathan, you both did an excellent job. I was very entertained and enjoyed it a lot. Thank you very much.
Thank you all.
That's all we have. That's all I've got.
Yeah.
Thank you for spending your Sunday judging us, and I really appreciate the feedback. It's very helpful and encouraging.
Keep doing what you're doing.
Thank
Both
you.
of you.
Thanks so much.
My pleasure.
All right. Without further ado, if I could just have the 4 advocates on screen, Nathan and Katie, and then Abby and Rochelle. And Mike and Roz and Don, love you guys, but trying to add to the drama here. There we go. All right. This was an incredible tournament. And for those who are just watching the live stream and are just seeing these trials for the first time, this competition started on Friday morning with 50 teams. We are down to the final 2 teams. Team 119 is from Hofstra. That's Nathan, excuse me, I already misspoke, already made a mistake. That's Katie and Rochelle, the 2 women in the bottom left of my screen at least. And from UCLA, team 147, Abby and Nathan. These were 2 incredible trials. For those who watched this live stream, the way that we did it at this tournament is there was no coin flip for the championship trial. There were 2 simultaneous trials where it was UCLA's prosecution against Hofstra's defense in one courtroom and Hofstra's prosecution against UCLA's defense in another. So we got to see 2 incredible trials. There were 3 ballots in each trial. The first 3 ballots went to UCLA. The next 3 ballots went to Hofstra. And unfortunately, there is no way to break this tie. So I am happy to announce that the 2024 Online National Championship co-champions are Hofstra and UCLA. Congratulations, guys. Thanks everyone for watching, for all of our teams and coaches and competitors and those who